Quote, you completed your term of supervision on 1/24/2011 and are no longer under the supervision of the Department of Corrections. I would like to extend to you best wishes for a very successful future. Joining me to try to sort through this from In Session on our sister network, True TV, field producer Michael Christian and contributor Sonny Hostin. Also with me, criminal defense attorney Rachel Kugel. Thank you all for being here. Michael Christian, any word from the courthouse behind you?
No word, Vinny. You know, court normally closes at 5 o'clock here, and that was about 30 minutes ago. So it's looking very unlikely that we will get any kind of decision today. It could be tomorrow. It could be Friday. All Judge Belvin Perry said last week was that it was not going to be on Friday, and it wouldn't be Monday or Tuesday. So that left today, Wednesday, still Thursday and Friday of this week to go.
Rachel, and I understand what a criminal defense attorney will argue here is that, hey, listen, you know, the state, if they made a mistake, it's on them. It's not on us. This is a criminal defendant. She served her probation. Just let her go. From your perspective,
That's right.
Is it that simple?
Well, from a defense perspective, it's that simple because there's a balancing test here, and there has to be some finality to these things as well. There's a question over whether they could even bring Casey Anthony back. Do they even have the jurisdiction to do that at this point? There has to be finality in these things. You can't continue to come after a defendant time and time again to change orders. I mean, there is a reason that there are time limits on this. There's a reason that Florida has a 60-day time limit to change that order.
How about this, though? What if she was let out of jail early? Let's say the Scrivener made an error and wrote 3 years instead of 30 years.
Right.
Should that defendant get out? I'll ask Rachel first.
There have actually... Yeah, there's actually been a case like that, and I believe in the end they didn't change that order, and they did let the person out. Yeah. So there's actually been, that's the closest case actually that they've been able to find to something like this. The difference here, she has actually served the full sentence. So probation was required, probation went to see her, probation says she served it. So that's where that double jeopardy argument comes in, and that's why it is in play here, because the difference in this case is versus some of the other ones that are being looked at is she actually served it. So it's even more of a good argument in this case than it is in the case that you speak about.
Sonny Hostin, I do, however, see a difference between serving probation as a member of the public community versus serving probation as someone who's in lockdown 23 hours a day by herself. To me, the purpose of probation is to make sure that the rest of us are safe from you when you are released. And the fact that you didn't get into trouble while you were locked up by yourself for 23 hours a day doesn't give me a vote of confidence necessarily. So, you know, a Scrivener's error? Really? A Scrivener's error? So if someone writes something wrong and it's done, that's crazy, Sonny, isn't it? A little bit crazy?
Well, I certainly think that the notion that someone can serve probation while in prison is really out there because, as you mentioned, probation is really being supervised outside of prison. It's an alternative to incarceration. So I think we were all shocked as practicing attorneys that this even existed. But when I looked back on the tape, Vinnie, it was the prosecution that brought forth the premise that it's possible for someone to serve probation in prison. They threw that out there, and I think because they were so confident that they were going to get a conviction in the case of Caylee Anthony's murder, that they threw that out there. They thought this was going to be sort of a non-issue. And now it almost seems like sour grapes to me, because I do think that it's pretty clear that probation thought that she served while in jail, right? They checked on her. They sent her that termination letter that we just put up.
Yeah, she didn't get arrested while in jail.
I think at this point it's over.
Yeah, well,
maybe I'm wrong.
Michael Christian, no, I understand all these arguments, and they all make sense on one level, but on another level, Michael Christian, it's silly. The whole concept is silly. She was in protective custody, locked down, having no interaction with any other human being. And to me, it defeats the purpose of any sort of probation sentence, especially when the judge specifically said in court when the sentence was supposed to be served. You know, because the judge realized that if she's in lockdown protective custody, it's silly for her to serve probation because it doesn't tell us anything, because obviously she's going to not get in trouble. She's not going to steal anyone's checkbook while she's in lockdown by herself. Is she going to defraud herself?
You're right. It certainly seems counterintuitive. However, we've been told over
No, I think
and
I
over,
said
Vinnie,
silly,
by many
Michael.
Florida lawyers. It's done here very commonly.
Michael, I think I said silly, but I think you may have used a better word, counterintuitive.
Counterintuitive.
Okay.
You know, it's interesting that you mentioned a moment ago the double jeopardy argument. When I was at the hearing last Friday, Judge Perry didn't seem particularly swayed by that argument, basically that she's already done this so she can't do it again. What he seemed to be more interested in was the issue of the legislative branch, the executive branch, the judicial branch. The judicial branch here is Judge Stan Strickland saying she's got to serve this. The executive branch, which is the Department of Corrections, the parole office, has already said, excuse me, probation office, has already said, no, she served it. So he seemed very interested in that argument about which branch of government actually ruled here. And the other thing he seemed very interested was the safety issue. You know, there's definitely the question of if Casey Anthony comes back to Orlando, is that a danger to her and also a danger to others who might be around her? So those seem to me to be more of interest to Judge Perry than this double jeopardy issue.
It almost sounds like Judge Perry just doesn't want her back in Florida. I mean, he's looking out for the rest of the people of the Sunshine State, maybe.
He doesn't want to pay for it. He doesn't want to pay for
And
it,
that's
Vinnie.
the other part of it. You're right.
Chief judicial officer. It's expensive.
Costs a lot of money. All right, now, if you want to stay on top of this story, and when this ruling comes down, I will let you know, but you've got to follow me on Twitter. Just follow me at Vinnie Politan as soon as we get word that Judge Belden Perry has made. I want to know what you have to say about it. And I've still got my guests with me, Michael Christian, Sonny Hostin, and Rachel Kugel. Paolo says she's innocent and a free woman. Get over it and eat your heart out, America. Justice for Casey. Rachel, would you concede that there's a difference between being found not guilty and being innocent?
Sure, absolutely. Being found not guilty at this stage means that the state could not prove beyond a reasonable doubt that she did it, how she did it, etc. Doesn't mean she's 100% innocent, and I think her parents alluded to that as well. But
and the
as
jury
Sonny
doesn't
said
come back.
earlier today, it's sour grapes.
Right, and a jury doesn't come back and say you're innocent. They say you're not guilty.
Right.
They didn't prove the case. Prosecutors have the burden. We know that. All right, good. Beverly writes on Facebook, you don't serve probation in jail. That wasn't Judge Strickland's orders. Tired of this girl getting special treatment. Sonny Hostin, do you think that Casey Anthony, despite, you know, the court of public opinion and all the pretrial publicity, actually, at the end of the day, has gotten some special treatment through the course of all of this?
I wouldn't call it special treatment, but I will say this, Vinnie. I think it's very unusual that Casey Anthony served probation in jail. Again, probation is an alternative to incarceration. So people are telling me that this is something that is not unique in Florida, that this is something that does happen while uncommon. So I'm not going to go so far as to say special treatment, but I do think that serving probation in jail is something that I've just never heard of.
Karen writes, I will be surprised if she has to serve the probation. She seems to be above the legal system. Michael Christian, that's the other thing. You know, we cover trials for a living, and when you have a high-profile case like this with results like this, and now it seems like, all right, well, she doesn't have to do what the judge said she had to do specifically. It looks like the system's a little bit broken.
I think, Vinnie, and this is just my opinion,
Sure.
I think that if Casey Anthony is ordered to serve probation, I think she will come back and do it. Last week, we were hearing from people in the probation office, and they said that they had been speaking to her attorneys and they had been cooperative. I think if Judge Perry orders it, she will come back and do it. So in that sense, she's not above the system. I think she will actually do it. Now, you know, we hear so much more about her than we hear about the average person. The Department of Probation said, well, you know, we're going to try and treat her the way we treat everybody else. Well, that's all fair and good, but you don't have press conferences announcing this sort of thing about everybody else. It's just, that's the way it works. But I think she'll come back and do it if she has to.
Great job, everyone. Michael, Sonny, Rachel, thanks for helping us out tonight. Appreciate it. All right, folks, a gang of outlaws on the run from police.